I'm Tim. As Professor Thompson mentioned, I'm here from Washington, D.C. As I was getting ready to fly here yesterday, I was getting dressed, and I said to my wife, honey, in your wildest dreams, did you ever think that I would be asked to come to the University of Houston Law School and talk to students about bail reform? Without blinking her eye, my bride looked at me and said, Sugar, my wildest dreams have nothing to do with you or the University of Houston. It's going to be one of those lectures. It is. Relax. So I'm here to talk to you about the front end of the criminal justice system, the way we process individuals after arrest up until the time that a disposition is reached in the case. Tell me why you're here. Free lunch.
No, that's not interesting.
What you're in? Go ahead, please.
I'm also working at the U.S. Attorney's Office.
Okay, thanks. Hi.
Hi,
Why are you here?
I'm a criminal attorney on the assistant campus.
And what's the interest in this stuff?
I thought we have a fantastic talk. A lot of most of our clients are indigent, of course. They have huge interest with respect to pretrial, bail, attorneys.
Okay, terrific. Hi. What you doing here?
Well, I am an LLM in health law, and I actually am going to be studying, or hopefully advocating for fetal rights, infant rights,
Right.
and to the extent that criminal law is emerging in that area, I just want to get to know a little bit more.
Welcome. And are you just here taking pictures? Uh-huh, good job. Get my good side, would you? I don't think I have one anymore. So how does bail work, ladies and gentlemen? Ah, see. She got the easy question. You get the hard one. People can't get released until they make bail, of course. And what's the purpose of bail? Go ahead, please.
To make sure that the person will come back and stay that money and pay back.
Perfect. And you were going to say? Right. So the purpose of bail is to make sure I show up where you want me to show up, and hopefully when you want me to show up, right? Any other purpose? I get arrested, I come for bail setting. What are you most concerned about? Are you most concerned about me running away? What are you concerned about? Sure. Are you worried about whether or not I'm going to commit another crime? I mean, that's what we're all worried about. We all want to find our bicycle or our car where we left it, right? We all want to come home and see that it's intact. We're all of us, regardless of our political stripe, our view of society in this grand republic, we're all concerned with public safety. And bail, since the 1980s, serves two purposes in this country: to assure appearance in court and to protect the community. Okay? And so how do we do that? I get arrested in Harris County, Texas. You're a magistrate. What are you going to do with it? Perfect. Thank you so much for that. Okay? Based on what? Based on, okay, I'm charged with grand theft. I've been arrested before. I've been convicted of a couple of misdemeanors. Reasonable? And what would that be? 10,000? Okay. It's a good number. Get your teeth into it, right? Yeah. Any other ideas on a number for me? It's not my first time through the system. I'm probably going to come back. I almost always do. Right? Yes, ma'am.
About 50,000, knowing that he's going to get somebody, or maybe, or backing up the money. But if he's going to repeat offender, maybe no bond.
Okay. So, again, we've gone from 50 to 10 to 50. And then while we're at 50, we're pondering maybe no bail at all. Right? Because
Because you said he's done this several times.
I've been convicted before, sure.
And he may do it again. He may come back again.
Okay. Fair enough. So what you guys have just discussed is not atypical of what happens in the criminal courts in America today. So let's spend about a half an hour talking about some of the myths and realities of the current pretrial justice system. And then let's have a conversation about whether or not that makes sense, whether you find it effective, whether it meets your expectations, and whether or not it does the job that we want it to do. In the United States, as we meet here this afternoon, 2 out of every 3 inmates in America's jails are not there as punishment for having committed a crime, are not there because they're so unmanageably dangerous they need to be kept incapacitated to protect our communities. 2 out of 3, think about it, you guys, 2 out of 3 inmates in America's jails this second are there because they don't have the money to get out. If they had the money, they'd be out. The court has said on the record, it only takes $10,000. Any threat to me or my community dissipates into the ether. Just give me $10,000 or give me $50,000, right? Astonishingly, most of those individuals, upon disposition, and most of those dispositions will be associated with a conviction because most people who get arrested have done something. So most dispositions are the result of plea negotiations and the like in criminal courts. Not all. That's what makes this so interesting. Not all. But most. Of the 2 out of 3 that are currently being held in jail because they can't play the game of give me some money, most of them, once we convict them, once we give them a chance to stand in front of a judge, raise their hand and say, yep, I did it, we send them home. So you have to ask yourself a question. If the purpose of bail is to get me back to court and keep me in trouble, what is it about me that's so scary? You have to keep me incarcerated while I'm presumed innocent. Yet as soon as I am legally determined to be guilty, you send me home. No, not everybody gets sent home. Of course not. But numerically, bunches and bunches of them do. So the exercise we went through at naming bail was actually quite illuminating because it was a very accurate reflection of our thinking. Bail in America, for the most part in our criminal courts, is set by what we call a bond schedule. And it's a menu. The judge has a laminated card. On that card is a list of offenses. Next to those offenses is a list of dollar amounts. It's how bail is set in the majority. My daughter came. Thank you so much. Really, you're welcome. bail is set in America most often, including here, using a bail schedule. Thinking back to what the purpose of bail is, how on earth could a price tag affixed to a charged title in any way, you guys, accomplish what we expect bail to accomplish? Get me back to court, keep me out of trouble. If I'm a professional car thief, the U.S. attorney gets laid off. I meet her at the coffee shop. She's crying because she can't pay rent. And I take pity on her. I say, come on, I'll teach you how to steal cars. We go into the parking lot on campus. She messes up because she's a rookie. Lights go on, sirens go off. All of a sudden, the place is lousy with cops. We get arrested. When you go by the bond schedule for car theft, it's $10,000. Who's going home tonight? Anybody? Me or her? Why? And I'm sorry. I'm going to have money. I steal cars. It's part of doing business. I got the cash. It is part of doing business. Like a locksmith has blank keys, I have cash in case of trouble. I am going to pay the money. I am going to leave. What's going to happen to her? Who's the bigger risk? What the hell? Right? That's how it works. This is not a criticism of stubborn judges or rigid prosecutors or overworked defenders. It is, in fact, a candid discussion of a system, excuse me, that is fundamentally incapable of doing the job that we expect of it. One that costs this country in excess of $9 billion annually. That's what pretrial detention costs taxpayers on an annual basis. Because you're in school and you have the opportunity to think about stuff in ways that you don't get to once you hit the workforce and your mind is working in different domains. I also want you to think about what incarceration means. What's the most severe sanction the state can impose upon me short of killing me? Locking me up. Short of execution, the most severe punishment government can impose is to lock me up. Yet that is what we're doing routinely. And we're basing that incarceration on a charge title more often than not. We're overlooking the purposes of bail, and instead, as many of you did, either by giving me the answers or the answers you thought of and didn't raise your hand to give to me, we're also sending a signal. We're also saying we're not tolerating this behavior anymore. We're assigning a cost to crime. Crime doesn't pay, and I'm going to prove it. You're going to pay me. And we do so with every good intention based on the mythology that money's going to do something. Money's going to make us safe. Money's going to reward me if I do everything I'm supposed to do. Money is somehow going to separate those who pose a danger to you and I and those who can safely be released. When in fact money does one thing only, and it does it really, really well. It separates those of us who have it from those who don't. If you got the money, like me, the professional car thief, risk isn't a factor. Cash is the factor. Why would we have such a system? long tortured answer. Up until the 1980s, the courts could only consider flight when setting bail. Then there was a Supreme Court case, U.S. v. Salerno, in the mid-1980s, where the question of whether or not the court could consider danger, whether or not the court could take action based on what we think I might do. Big stuff. Not on what I've done, but what I might do. And whether or not the court could consider my potential danger and whether that was an appropriate consideration of bail. And the Supreme said, yeah, that's absolutely right. It was a U.S. federal case. It was actually a D.C. case. I was working in D.C. at the time, and it resulted in the inclusion of danger into state legislation so that judges could now, above the table rather than under the table, consider danger. William Rehnquist was the Chief Justice at the time of the Salerno decision, and in that opinion he wrote, "In our society, liberty is the norm. Detention prior to trial is the carefully limited exception." Most of you get arrested tonight. If I get arrested tonight, if my daughter gets arrested tonight, detention will in fact be the carefully limited norm, because if we don't have money, we have credit cards or we know someone who does. But guys, we don't get arrested very often. You go to the criminal courts in Harris County, you don't see a whole lot of us. You don't find people who have gotten through undergrad. You find pretty much the lower strata of our society. And when you tell a population that is economically disadvantaged, you know how the justice system works? If you pay, you play. That disadvantage then becomes exacerbated at the very moment of arrest. But I'm not talking about a couple of poor people who are getting the short end of things, and can't we do something about them? I'm talking about a system that's inherently broken, one that turns a blind eye towards dangerous defendants that can raise enormous amounts of cash through illegal enterprise, and we pretend everything's great while incarcerating thousands of individuals who pose no more risk to community safety than most of you. And we act as though it makes sense. We have to have a system where risk is recognized, because risk is in fact present among this population. But it's not a homogeneous population. Not everyone charged with car theft is the same cat. The risk she poses and the risk I pose should be assessed and mitigated appropriately. But you live in a country where that is not routinely done. It's okay, Mr. Murray, because maybe she doesn't have the money, but you know what? Her grandmother does. Her grandmother has a house, and the grandmother's going to put up the deed to the house, and she may steal from you, but she's not going to steal from her grandmother. One of the many myths of how bond works in America. In most bonds, there is no grandmother's house. The decision is made by a private, for-profit business that either releases you or declines your business based on whether or not they can make a profit. The era of putting up my grandmother's house is long gone in most cases. Most money bonds are written for what is called the premium. That's the fee you pay a private business to write your bond. It's usually regulated 10% or so is the national average. If I pay you, my bondsman, $1,000 on a $10,000 bond, and I do everything I'm supposed to do, and I come back to court on time every single time, and I don't get in any trouble, how much are you going to give me back? You're not going to give me a penny. Once I give you the money, it's gone. Not inappropriate. That's the nature of the contract. I give you 10% of the bond, you keep all of it. If I get arrested for committing more crime, is that a violation of the bond? No, it's not. In most jurisdictions, whether or not I get arrested is not something for which the bonding agency is held liable. So let's think about it. Release is based on my ability to put cash on the barrelhead. The cash I put there is gone forever, so that incentive that we have all grown up with thinking is there to keep me doing what I'm supposed to do turns out not to exist. It does absolutely nothing vis-a-vis danger, only appearance. Money bond was in use before the Supreme Court ruled the danger was appropriate, yet Texas and other states continued to use money as though it somehow magically addressed both danger and flight. It obviously discriminates against those who don't have money. It favors those who do, regardless of where they get the money. What else does it do? One really fascinating fact. Over half of those who get arrested in America who are most likely to reoffend and to fail to appear, measured using a validated risk instrument, over half of them are getting out. Over half. Over half of the most dangerous, the most likely to flee. Not surprising, they have access to dollars. Conversely, when you take low-risk defendants, and by risk, we're defining it as my likelihood of committing more crime or skipping, not coming back to court. You take the lowest risk individual who's being held not because of their risk, but because of their economic status. Remember that, right? You leave them in jail pre-trial for just a few days, and you compare them with an identical cohort, statistically significant cohort, same charges, same criminal histories. The group that's locked up pre-trial commits additional crime at 2 to 3 times the rate of those who get out. So we're releasing the most dangerous half the time. We're taking the least dangerous and we're making them more dangerous. All in the interest of administering justice, addressing risk of flight, and assuring an orderly and rational criminal case process. Any questions? There's got to be a better way to do this, you guys. Bless you. Any ideas? How can we fix this? There's a couple of other really interesting effects of the current system. Bail in America, pretrial justice in America, is a gift that just keeps on giving, right? High-risk guys are walking out. Low-risk guys are becoming higher-risk guys because of their incarceration. And if you're puzzled why that is, and no one knows scientifically why low-risk people become higher risk, but we know empirically they do, it's easy to imagine, but it's only my imagination. If I'm a day laborer, I'm paying rent by the week. I'm literally bringing home my family's meal, and I'm gone for 5 days because I'm locked up. I don't have a job. I don't have a place to live. My family may now be in foster care or God knows where. What recourse do I have? Who am I associating with? People in jail. Tim, I know how we can get a couple of bucks. Right? So it's not a quantum leap to imagine how easily people that are so fragile socially and economically can move from low risk to higher risk. Know how to fix it. And please.
Coming from concentrated disadvantaged neighborhoods, so if we work on children and keeping them out of that behavior of following their parents' lifestyle,
Absolutely. But we don't have that option. We're working in the Harris County Criminal Courts. As much as we love children, and we all do, I got to deal with their knucklehead uncle and mom and dad and older brother. That's my business. That's what I'm getting paid to do, right? And currently, the way I'm doing it resembles the way it's done in almost every county across America. I'm using a menu of amounts, and I'm determining who gets out of jail in your city, where you're living right now, where you're going to school, and who doesn't, based on this hypocritical premise that somehow some magic amount of money is going to make us safe. You got a way to fix it? Say again? I didn't hear you. That's not unusual. Payment plan. So that answer is actually one that is being done in many communities across America, where bondsmen or bonding agencies are running into criminal defendants who cannot afford the 10%, or the competition among those places for the business is so treacherous that they offer discounts or payment plans. But that still leaves us with the same conundrum. The money doesn't do anything, right? So in the early 1960s, there was a philanthropist whose wife had just passed away in New York. He got a bunch of law students together and he sent them out to the city. And he said, find me the areas of greatest social dysfunction, and I'll spend my money trying to fix them. So they looked at education and child welfare, they looked at health care, and they also looked at the tombs, which were New York City's jails in those days. And they found there were more people in the tombs for want of $100 or less than any other reason. And they all concluded, wow, that's pretty crazy. We'll pay the bail for them. So the Manhattan Bail Project was started. They took this philanthropist's money and they paid bail for people. They paid it for her and for her, for him and for her. And you know what happened? They came back to court. Said, wow, this is an awesome project. Let's do it some more. So they paid bail for all of you guys. And with the exception of him, because we all knew he wasn't coming back. I mean, really, if I could just hit pause for a second, who thought for a second this guy was coming back, right? But that's how it works. We're blind to risk. He's charged with the same thing those other guys are. You all get the same bail, right? Everybody comes back, and it occurs to some really smart person at the moment in 1962 in New York, wait a minute, why are they coming back? It's not their money. They don't even know me. They didn't see me take somebody else's money and pay it. They just know they got out of jail and they were given a date to come back. Why are they coming back? And that actually started bail reform in America. That quickly resulted in Then Attorney General Bobby Kennedy convening the first national symposium on bail reform and calling for the dismantling of a system of release based on personal wealth, and a call to replace it with one that addresses risk. So now it's 2014, 50 years after Bobby Kennedy issued a national challenge to get it right. Stop releasing dangerous defendants who have access to means. Stop punishing poor defendants who pose no risk. Again, none of this is a reflection on what we think of these individuals in terms of whether they did it or didn't. We are following the legal purposes of bail, which are very straightforward and very easy to understand, yet often mangled beyond recognition. It's embedded in our psyche that if you get arrested, you should pay. We'll say out of one side of our mouth, everyone's presumed innocent, but when you go to criminal courts and you look at who's coming through it, you're saying, both officially and to yourselves, give me something. Show me you have some worth. Show me you're different than everybody that you're chained up next to. That difference being a couple of bucks, I'll let you go. Okay? There's got to be a better way to do it, and it turns out there is. Daughter who just started college. Last year, she got her driver's license. Be afraid. Be very afraid. She's in Maryland, you're in Texas. Be very afraid. And when my little gift from heaven passed her driver's test, God knows how that happened. And I go to Geico or Nationwide or State Farm and I say, hey, how much to insure my princess? Without blinking an eye, they say $43 billion. So are you kidding me? How much do you guys charge me? We charge you $1.87. Think about it. But wait a minute. We're both drivers. Wait a minute. We're both charged with car theft. It makes sense in criminal court to treat us the same, to respond to us the same. Why isn't everybody else doing it? Why doesn't my doctor look at me the same way as he looks at you after the life I've led? He understands my characteristics and my risks. Insurance companies, healthcare, homeland security, almost every domain in our society uses actuarial risk. They look at the characteristics that are associated with failure, and they project risk based on that. They look at my princess and they realize she's going to drive distracted. She's going to text and drive. If she has other kids in the car, she's hell on wheels. And honestly, she can't drive for crap, right? She just doesn't know how yet. Does that mean she is going to have an accident? Bad example. No, it doesn't mean she's going to have an accident. That means the probability is significantly greater than me. Although I am going to soon move into a cohort that's going to be just as risky as her, as we all know. Thank you for laughing at that. I'd be much happier if you'd go, what's he talking about? But their business is based on the successful assessment of risk. Wouldn't it be awesome if our criminal courts based the assessment of risk that we mandate that they respond to in ways that were scientifically valid? Not to take the place of decision makers, but to inform the decisions that they make. Not to release a couple of poor people, but to identify the really scary guys and have everyone focus on making sure that their threat to our safety is appropriately mitigated. to take the money that we're now spending to incarcerate people and use some of that to mitigate risk for this huge gob of people who come through our courts, boys and girls, who are right in the middle. They're not the scariest of the scary, and they're not virgins and Boy Scouts. They're very few at each end of that spectrum. Most folks are in the middle. Most folks have gotten in trouble. Most folks have problems who come through criminal courts. Most of them need some kind of monitoring or supervision. Neither one of which do they get under the current system where they pay money. So when we look at my daughter, Geico says, this is what we're going to do to mitigate risk with this kid. She's not allowed to have a passenger in the car who's under 18 years old. She's not allowed to drive at night. If she is caught texting and driving, her policy is permanently revoked. She has to go through driver's ed before we issue the policy. Here's what I'm going to do with you. You're going to come in once a week. You're going to tell me that you're still living where you said you were living. You're going to call me if anything changes. And because of your drug use, we're going to send you for an assessment to determine whether or not treatment's appropriate or whether or not you're just some knucklehead that's getting high on the weekends. Because if that's all that's going on, stop it. If it's something more serious, it probably is going to have a significant impact on your ability to come back to court and stay out of trouble. And we want you to come back to court and to stay out of trouble. Any questions? Actuarial risk tables have been developed and are now in use in a growing number of jurisdictions. It's data-driven, it's research-informed, it's blind to race, economic status, it's not blind to risk characteristics like criminal history and the incident offense. And again, it helps decision makers make decisions that are rational, transparent, and successful. It helps prosecutors aggressively respond to those who pose the greatest threat. It helps defenders secure the release of their clients who are being toxified by being kept in county jail pending adjudication. Well, you know, that's great, but it wouldn't work here in Houston because we're very conservative here in Harris County. The public here is very law and order oriented. We want our pound of flesh when an arrest occurs. All this science mumbo jumbo just isn't going to cut it. So we just conducted, where I work, 2 years of national public opinion polling on this issue for the first time in history. Never had the benefit of any of this. And when we asked the general public, being very careful to ensure that the pollsters got a sampling of what we would all agree is the general public. Democrat, Republican, rich, poor, middle, all socio-ethnic and demographic groups. And we asked them, do you think the court should use risk assessment to determine release or use cash amounts? 73% said risk assessment. I thought that was okay, but that's like a C, right? The pollsters' heads exploded. And they said, usually when you ask the general public about stuff that's so esoteric that nobody knows anything about, the biggest answer is, I don't know. And then you have a sampling that says yes and a small sampling that says no. However, in this one, 73% said they support or strongly support the use of risk assessment. Turns out the majority of the public, 70%, thought that's what we're doing now. We held individual focus groups around the country behind these two-way glass things. If you guys ever get to do this for a living, it's awesome. And they have a facilitator, and they've got a bunch of white college-educated women and Hispanic women and different groups, and they're coaxing them or coaching them through an hour-and-a-half conversation each. Every group said, "Why are you talking to us about this? Isn't that how it's done in criminal courts?" "Well, no, it isn't." "Well, how's it done?" "Well, we have dollar amounts that correspond to charges." "Why would you do that?" Good question, you guys. Why would you do that? So here I am, prancing around, barking and biting about it's time to change an ineffective, dangerous, and discriminatory system. Who on earth would support those kinds of changes? The American Bar Association, the Association of Prosecuting Attorneys, the National Association of Criminal Defense Lawyers, the U.S. Department of Justice, the Conference of Chief Justices. That's the club of every Chief Justice of every state Supreme Court in the land, who came out with a white paper last year that said, in America today, for the poor, bail means jail. It's a quote from the Chief Justice's white paper as they called for a dismantling of an ineffective and irrational system. The National Association of Counties, the International Association of Chiefs of Police. I'm up to my neck in cops. Pretty crazy given the kind of work I do. But I have more chiefs of police as my not only partners, but aggressive partners than any other stakeholder group, because cops see firsthand how bizarre the current system is when it turns a blind eye to risk. Cops see truly dangerous defendants being released with ease, while those who they know have no business being kept in a jail cell stay there for months or weeks. The states of Virginia, New Jersey, Colorado, Delaware, Maryland, Kentucky, D.C., the list goes on, are all legislatively overhauling their bail legislation and their bail practices. The MacArthur Foundation has just announced they're rolling out a $75 million initiative to help localities reform their current practices. The Arnold Foundation, which is located here, is the one that's responsible for all of this really cool research that we now have that shows us most of the scary guys are getting out and low-risk people are becoming higher-risk people. And the U.S. Department of Justice today announced for the first time in almost 40 years a pretrial justice demonstration project. Attorney General Eric Holder convened the second national conversation on bail reform with my organization the year before last. And that turned out to be the seminal event in starting a wave of momentum that is resulting in a significant change in the way our courts are making these decisions and the accountability associated with it. I'm going to leave where I started. Think about the purpose of bail. In your own heads, you know the purpose is to assure appearance and to ensure community safety. But you also know, by our conversations here today, that it's used to serve a whole bunch of inappropriate reasons as well. And it fails in its current configuration at almost all of it. You want the same thing I do. A justice system that is rational, transparent, blind to class, one that provides for safety, it doesn't damage it, and one that is easily explainable because it makes sense. As you leave school and you go into the court systems, it's not always going to make sense. But don't forget it's supposed to. Don't forget your role as someone who is a walking, talking, thinking educated representative of what all of this is supposed to mean, and never, ever consider that you have an option of shrugging your shoulders and saying, doesn't make any sense, but that's the way it's always been. Accept the responsibility that you earn with your education and with choosing the profession that you're choosing, that justice, in order to be just, has to be administered evenly and fairly to all who come into our systems. Any questions? Not one? That's perfect. Thank you. This is my nephew. Yes, sir.
So one of the reasons I pursue a lot of modalities and jurisdictions don't switch over to this in light of all the obvious support for this change up price and the cost. So
Good question.
costs a lot. What if it's not that? What are the other real barriers?
So do you have a guess as to some of them other than cost? Let's leave cost there for a second and we'll come to it. You have any other ideas as to barriers to change?
I guess it would probably be like smaller localities. So let's say Texas is trying to grow.
Right.
I would say some of the smaller counties or areas would say a lot of resources to allocate gravel and to get all the necessary information.
Sure.
Whatever it is that's necessary for the program.
Very smart.
How it all together. So just like this table is simple. You're trying to do something complicated as possible. So I just see that happening.
You really are my nephew, aren't you? No, thank you for paying attention. That's a very thoughtful assessment. So it turns out that it costs a whole lot less to release me and keep track of me than it does to keep me locked up. But the costs that we're spending to keep me locked up are kind of written into the budget and negotiated as an appropriate cost of maintaining, in most cases, county government. When somebody jumps up and says, I've got an idea, let's screen everybody and supervise them, and it'll only cost $1.19 per guy as opposed to the $46 million a guy it spends to incarcerate them. It's still in the world of a county budget, that's money that doesn't exist, right? The money spent for the jail is money that everybody already fought for and negotiated and appropriated. This is extra money. So in Harris County, there is a program, okay? There is a program that screens people and provides supervision. So that's not the issue. What might be the issue is that change is really hard. It's really hard. You guys are going to see that when you go to work. They're going to teach you how to do something, regardless of your job. Let's say you're going to be an assistant state attorney, okay, or district attorney. They're going to teach you what that means. You're not going to be spending a whole lot of time going, well, wait a minute, why do we do it that way? Because he's learning how to do it right next to you, and we're only going to keep one of you the next cut. And everybody knows that, right? And so as you go up in the system, because you learned how to do it really well, there was very little time or opportunity to ask, should it be changed or how it could be changed. So change is really, really tough. In criminal courts, an awful lot of folks that are in policy decisions are publicly elected, right? And so think about the risk that's associated with me as your elected district attorney, for example, to say, hey, looks like I've been doing it wrong for the last 20 years. Geez, who knew? But I got a good way to do it now. I'm going to fix it, right? So don't worry. I'm on the job, right? That isn't going to happen. And so that's why I said this is not meant to be critical of the individuals. It is critical of the system. How this stuff happens often is that one jurisdiction will do it. Somebody will pay attention to it, look at the outcomes, look at the costs, and say, why aren't we doing it that way? She's going, I didn't know I was supposed to do it that way. And then you start to build momentum. I talked to you today at a time where momentum is at historically high proportions. There will soon be more states that are actively engaged in pretrial justice reform than not. That doesn't give us a pass, because we still have this natural tendency to disenfranchise those who don't have social standing. It's a fact. It doesn't only happen in criminal courts. And we tend to try and find as many shortcuts as we can because there's so much stinking business. And when we find shortcuts, people get trampled. Thanks for the question. Thank you. Thank you.
Thank you.
Thank you.